and under his leadership, since the CSL has conducted various national and international conferences, workshops, and published newsletters, books, and articles in the aerospace law field. We are honored to welcome you, sir, onto this special session, and I would like to hand over this on to and preside and welcome to this particular kind of a session, and we will have his particular kind of elaborated knowledge base which he can share with us and which will be useful to every one of us. Thank you.
Thank you for the introduction. Good evening to everyone. Today's discussion on contemporary challenges in international law, COVID-19 pandemic perspective. Okay, so my discussion will be maybe three important components I'm going to look at. One, technology. Today, international law or various branches of international law having a lot of issues with technology. I'm going to look at the linkage between law and technology, or how technology is helping the society, but where legal problems are coming. We always say that law follows technology, or technological developments needs law. But there are certain areas where technology is moving ahead, but law is not catching up. Many international areas, whether it's air law, space law, IP law, IT law, cyber law, all those. So that's why one small component or 15-20 minutes of my discussion will focus on the technology law. Then second component is how this pandemic is impacting, actually the impacting on business and community, social, economic, political, all these, the impact of COVID on various aspects of a community or society. So then how business is going to impact, how industries are going to impact. Then I'll give brief introduction about the COVID and various legal implications or issues. Then my third part, I will focus more onto the various international law issues pertaining to COVID or COVID impact on international law issues. I'll begin with today. Last 4 to 5 months, if you look at, a lot of discussion is is happening that can China be responsible for all this pandemic, because it happened in China, but China not informed to the global. The responsibility of China to inform. But can we sue? Can China be sued? This kind of discussions are happening. So to do that, I will begin with what is the state responsibility in international law, then how China can be brought, or if so, what are the international provisions which international law can apply. Then I'll also focus some important areas, because we have a limited time, but I'll touch upon at least 5 to 6 important issues, international law issues. Maybe we can begin with international air law, then international human rights law, refugee law, health law, international trade law, environment law. These are some of the issues I'm going to touch, and what is going to be the impact of COVID on human rights, COVID on environment, COVID on aviation, so like that. So I'll begin with first part, that is the law and technology. Friends, you all know that again, law follows technology, or technological developments necessitate the legal regulations. It is true with aviation or space or defense technology. So this is a technology law. But if you look at, I can give an example of few techno-driven laws. What I last part of my this slide, if you look at, there are certain laws which have complete in consonance with the technology developments. For example, aviation law, space law, IT law, IP law, cyber law, all these things. So the linkage between technology and law. Here I just gave example of aviation. Last 100 years or plus, the invention of aircraft by Wright brothers, actually, what kind of developments are happening in the technology, how law is evolving. Particularly here, the important treaty, what we call in air law, is the Chicago Convention. It is a charter for aviation activities. Then there is an organization called International Civil Aviation Organization. How this organization is trying to enforce these technological developments. Normally, air law, there are 19 annexes, technical annexes, which oversee the enforcement of developments. So like that, I'll look into this aviation. Particularly, if you look at ongoing developments in technology, illustrates that law lacks science, it does not lead. So we have a problem. Law, not catching up the developments with the technology. So particularly earlier, whether it's a aviation or space or any kind of technology, it was only confined to scientific areas. But today, technologies are also have been commercialized. Business is happening with the technology. Litigation is coming up. That is where the requirements of law comes. So here that gap is there. All these emerging areas of international law, particularly here I mentioned few examples here, including air law. Air law I mentioned to you, air law. Then space law, but again other important area is space law, space technology. Though aviation began in 1903 by Wright brothers, space law began in 1957. On 4th October 1957, successful launch of Sputnik 1 by former Soviet Union. The space era, space age, or fourth dimension of human activity started. This is called human fourth dimension. What are the other three dimensions? Man started his activities on the land, then land law. Then he ventured into sea. We know all law of the sea or international law of the sea. Then aviation law, then space law. So that's why this is called fourth frontier, or this is the beginning of space era, space age, all those things. And friends, if you look at how technology is actually negating the legal problems, technology is going fast. Last 60 years, so much development happened in the space or space technology. Today we are Neil Armstrong, Aldrin, all those man, moon, and the space. Today space stations, space hotels, space tourism. People are talking about space tourism. Maybe very soon it's going to be a reality. So all these new developments are happening. I can say in summary, all these developments, actually today we are living in age, space technology, using space technology to solving the problems of humankind. That is what we entered, a new era of solving the problems of Earth from utilizing technologies in general or space technology. And today, all these happening because of satellites. Today you are sitting there, I am sitting here, we are doing activities because of the satellites. So this is what the technology, but unfortunately these technological developments, there is a gap. Law is not catching up. That's what I'm going to try here to say about what are those gaps. And this is with space law. Similar thing with IT law. If you look at information technology, or now what we call is information communication technology, that's also going loops and bounds. So legal regulations are not up to the mark. Though we have international legal regimes, domestic legal regimes, all those, but it is not catching up. And IP law, of course, have a slide I will discuss later on how IP law is actually evolved and what are the gaps. Cyber law, telecom law, all these this is what I call technology and law, techno-driven laws. So this is. Then of course, is it that we are talking about technology because of recent thing? No, friends. Just to look at technology is there, is going to be there. But how the evolution of technology happened in international relations or application of international law? If you look at ancient technologies, invention of ramp to aid a construction process, all those. Then these technologies were used way back in planning and sanitation of technologies in industrial civilization, safeguard seafaring technology, early seismic detectors. All these technology was used, but in a different context. So evaluation of technology, and now we'll look at. So improvements are there in the technology. So if you look at medieval technology, more improvements happened, particularly vertical windmill or dry compass, textile manufacturing, communication technology, paper making. These are new emerging technology. One important event happened in this era was the invention of printing press by Gutenberg. Actually, this is revolutionized the entire thinking in international law, international relations. So exchange of ideas started with this invention of printing press. Those inventions, sea trade, sea routes, then Renaissance, the Reformation movements, relate to the situation of interstate relations, international relations in the international context. Of course, these are all only just for idea, but today we are living in a modern technology or 21st century. How this technology is impacting on day-to-day life of our thing is more important. That's why the modern technology, broadband internet access, quantum computers, nanotechnology, biotechnology, all these are new technologies. I'm going to discuss new and emerging technologies, part of that, but these are all modern and new technology which are having a lot of impact on legal relations, governance. That's why I am putting here this. So friends, of course, when we say we are going to talk about the linkage between technology, law is not giving problems to the emerging technologies, but how these technologies evolved, particularly in the late 18th, 19th century. There are three industrial revolutions before. Now we are in fourth industrial revolution. First industrial revolution in 1760s about coal, water, steam, or invention of steam engine, which led to the mass production between the countries. So interstate relations through production, through manufacturing started. So second industrial revolution, particularly 1860s, if you look at invention of electricity, that is the important development, I can say that, which enabled mass production. So first steam engine, electricity, then industrial revolution is digital revolution. We have seen 1950s and 60s how these digital revolution happened, and which made actually the globe into the global village. Okay, global, because of technological development or digital revolution. Today what we call is the global village. So this is so far history, but today we are in fourth industrial revolution, which is going to have a lot of impact on interstate relations or international relations. So if you look at these technologies like fusion technologies, which are thinning the gap between physical, digital, biological space. No much difference between these layers actually. Fourth industrial revolution, if you look at it is almost disturbing every almost it is disrupting almost all industries. It has a both good and bad. So that these are all making good for comfort for the humanity, but at the same time these technologies also having a lot of negative implications. So that we have to look at those good and bad or pros and cons of the technologies. Particularly when I say fourth industrial revolution or current revolution, we have all these Internet of Things, artificial intelligence, robotics, and 3D printing, nanotechnology. But all these are all technologies. That's why I call emerging technologies, new and emerging technologies, which actually improved the what is the good about these technologies? Potential to rise global income levels, improve the quality of life for population around the world. Technology has made possible every product and services that increase the efficiency, pleasure. So these are good about, but these technologies also creating problems for law or enforcement problems that I will focus more into that. So here, yes, coming to these technologies impacting international law. Today, my talk is, of course, I'm focusing on the pandemic or COVID, but before that, these technologies also, part of that pandemic are, both for good and bad. So these emerging technologies, normally how to understand these technologies, I can give you good, just example, what we call A to Z technologies. A means artificial intelligence, to automation, to big data, to blockchain technology, cyber technology, cloud computing, cryptocurrency, drones, all those you go on, adding these technologies. But we as a lawyers, you may ask questions are what we have to do with the technology. So last 10 minutes you are talking about the technology. Yes, I am coming to the point. Yes, technology creating problems. Okay. Legal issues. That's what my discussion. I'm going to put certain important, pertinent questions which are going. I don't have answer to these questions. There are certain questions. There is answer, but certain questions still answer is not there because these are evolving technologies. So what kind of legal issues the global society is facing is a big question. Yes, to understand these legal issues, we can look at traditional legal issues. Modern legal issues are the technology which is impacting the traditional issues like state sovereignty, state jurisdiction, state responsibility, privacy, data protection, security. All these are all traditional technologies or traditional concepts we talk. Why this traditional concept I am saying? Friends, international law means interstate law. Okay, I'm talking about international law, interstate law. Sovereignty is important in interstate law. International law, sovereignty. Consent of states is important. Sovereignty is important. Of course, today sovereignty has diluted in the context of technology, in the context of globalization, in the context of liberalization. But state, sovereignty is important concept in international relations. But there is a dilution because of use of technology. But we can't overtake that. So then jurisdiction, for example, how these technologies are impacting jurisdictional problems. Earlier, we used to talk about the jurisdiction based on the territoriality principle, citizenship based, all those. But today, no more. Those are all. I'm not saying they are not valid, but they are redundant to some extent. So new jurisdiction issues like global jurisdiction. We talk about the universal jurisdiction. Territorial too. We are talking about the universal jurisdiction because of the technologies have cross-border in nature. You can sit here and do some activity which is impacting other parts of the world. How to regulate? How to control? Do we have a mechanism to regulate these things? Friends, you all know, we are all lawyers, law students. As long as you are within the country, you can enforce regulations, but these are all cross-border in nature. How are we going to look at? So maybe in my talk I will explain further, but these are concepts which are having a lot of impact on the use of technology. State responsibility. Today we are going to talk about the Chinese responsibility in international law. Is China going to be liable because China is responsible for spreading of COVID-19? And what about privacy issues? Today we are talking about facial technology, all these, but are we not losing the privacy in security? So these are definitely questions, and I know already some jurisprudence developed are some areas, of course, still not exactly answer I can give you, but yes, these are all issues pertaining to traditional concepts of international law. But if you look at, and I'm talking about new technologies or new and emerging technologies, what are those new technologies which are having legal implications, including misusing of data, e-evidence? We talk about e-evidence, protection of creative works and inventions, IP, mobile technology, and then facial recognition technology. That is having a lot of problems. You go to airport and they install missions, and they are looking through facial recognition technology. But are you not using your personal rights? All so these are some of the challenges or issues. Technology and law are having a problem. So these technology are creating problems. Or to put it in short, last 10-15 minutes discussion, what kind of legal issues this technology is posing? Okay, yes, the existing legal regime is unable to deal effectively with the new and innovative technologies, are also raising a lot of legal questions. We as a students are, I'm a student of law. What is that law which talks about, poses question about the technology aspect is, do machines have morality? Today we are employing machines and that they are doing, but what about, do we have a moral? Do machines have a morality? What legal liability regime should we adopt for damage arising from these technologies? Okay, which ethical guidelines should we adopt orient advancement of this technology? And then what kind of justification we can give when we use these technologies? Should the legal system should resort to precautionary principle? Those are the technology based incentives necessary, product specific, are those are general. I'm just doing some research, I'm just raising, but these questions are very pertinent to this technology. Yes, these are all, again I'm repeating, there are certain answers to question, but still law is evolving. That is the whole my purpose of discussing with you, is that these technologies are posing problems. We don't have a legal solutions. So it is a time for us to look at, when we talk about interstate relations or international law, how these technologies are impacting, where the gap is there, how we can overcome this thing. So this is what I thought first part. Okay, technology and international law are emerging issues in international law. Then come to the second part, important part. We have to look at not only technology but emerging international issues in the context of pandemic. Friends, we know the pandemic, which last 5 months, every day, every minute, we are listening, hearing, talking about the pandemic. I need not talk about, but there are this is creating a lot of problems. Pandemic has forced states to close borders. Okay, quarantine imposed on people, travel bans, paralyzed supply chains, import export restrictions. All these are all we are witnessing for last 5 months because of COVID or pandemic. So impact pandemic again pose fundamental questions. Okay, we as a lawyers, what kind of questions this pandemic is posing when we talk about interstate relations? Yes, if you look at it, says, how will the pandemic influence on international order in the future? Is it that international legal order going to continue what we are practicing for maybe last 30 years, 40 years? Are we going to change the legal order in the context of COVID, or international relations in the context of COVID? and how the pandemic, might reshape the world order, including prospects for international cooperation. International cooperation is important, but are we going to continue international cooperation? If you look at, friends, the relations between China and America and other countries, how this pandemic is adverse interstate relations are happening over the last 5 months. So how about the cooperation, coordination, what we practice so far? Are we continuing with that, or what kind of shape it is going to take? I don't have answer, but I'm just posing. I'm just giving leaving to you. Can the pandemic will escalate USA decline? This is the one important issue in international interstate relation or international relations. We all know that earlier it was bipolar world. Today we are unipolar world. American dominance. But today question is that whether America is going to continue with that unipolar world or dominance in interstate relations. Why I'm saying this means United States Trump administration has failed in preventing, curtailing, and actually this pandemic. So a lot of internal, external criticisms are coming. So today, when it comes pandemic, jurists says that US is a failed state in international relations. So what is going to be the role of United States post-COVID? Is continuing with that hegemony, or again it's going to dilute? Is again big question mark. So world now faces new form of non-solidarity, globalization between countries north and south. Okay, trade war between US and China. These are all issues which we are witnessing. I'm not saying but last 5 months these are issues which happen. These issues are again posing particular trade, business, general environment. So what kind of issues these interstate relations are posing? If you look at, we as a lawyers are how this can be looked at. What sorts of guidelines or inputs should guide design product, or how desirable are knowledge sharing agreements? What is our role to be? Our role means researchers, scholars. So these are all issues which are going to today. The trade commodities are taking a new shape. So how are we going to sustenance is becoming a big question. So what kind of product we need? Today we have to take quick decisions. Particularly in the context of pandemic, survival, fittest of the survival. That was the old, but today I'm saying that quickest of the survival. Today you have to take very quick decisions so that you can a bit again come back. So from fittest of survival to quickest of survival. So lot of legal questions are it posing. Joint development technology know-how. So earlier we used to have a technology transfer of technology. These joint development technology know-how going to continue. Take example of India and China, India and US. We have banned lot of technologies. 59 caps, and later on 20. We have banned technology. So what about this technology? So okay, of course, India as sovereign country, we have a right to ban any trade subject to when it comes sovereignty, sovereign integrity, whatever. But it's not that good international relations. I'm talking about international relations. You can't suddenly say that do away this. So what kind of repercussions, implications are there is a big question. How should the management monitor competitive activity? How can competitive advantage created to sustain industries in the context of pandemic? All these are all issues. But what is the impact on international relations? Those things is domestic governance. Today, impact of COVID on domestic institutions. Every institution is suffering. So this is that's why no industry has escaped the impact of COVID-19. Just to give example, friends, some are hard hit, some are not so. For example, travel, tourism, entertainment, hotel industry, steel, textiles, all these are very hard hit. For example, aviation. When it is going to normalize is a big question. How much time it takes is a big question. There are certain other industries where they have damage or problem, but compared to the first one, they are not so, like food, beverages, paper, pharmaceutical, industrial machinery. These are some of the industries which have impact, but compared to those not so impacted. So this is ongoing. Restructuring was put motion as a result of the globalization of market, downsizing, consolidation, reconfiguration of common terms used to describe the current affairs, all these issues. So how domestic governance completely today standstill. I can say that domestic institution, domestic governance has standstill because of this pandemic. So this is regarding to that. But what we have to do as a lawyers or law scholars or legal luminaries like you are. So what is our, how are we to look at, because it's the research. That's why I'm posing a lot of questions so that you can do, we all can do research. So here, if you look at as a research scholar, because this whole 10-day session is going to be the research teaching, that's why these are all researchable questions. Okay, COVID phase, Paria's most important contribution of legal profession can make is to assist managers in the achievement of sustainable competitive advantage. As those who guide the business enterprises search for source of competitive advantage, we as lawyers, their efforts can be facilitated greatly by legal professionals. It is best if legal and management other, we can give good solutions or good, answers to the ongoing problems. Many I have, jotted down 3-4 slides only on how we can help the other industry managers or industry leaders, what kind of legal advice you can give. Okay, whether it's product, whether it's a service related or product related or intellectual property related, all these have a lot of questions. What kind of guidance enterprises required now? Because enterprises, some I mentioned you, are almost like aviation. They have bankruptcy. They are not in a position to. Of course, I don't think another 6 months or 1 year industry will come up. So if that is the case, what kind of guidance they require, what kind of advice they require, what kind of financial help they require, all those we can guide, give advice. So particularly here I said what kind of guidance enterprises required, how should the firm be interacting with external partners like suppliers, buyers, competitors, all those very pertinent questions. Okay, so there are other important issues like legal agreements, conflict resolution. How are we going to do that? So, okay, intellectual property. Of course, intellectual property I referred. I'm going to refer again. Standard product liability, dumping, anti-dumping, international business ethics. Are we going to continue with the business environment or business ethics what we practice so far? Like again, China and other countries, what they are doing. So these are all now big questions, including environmental impact. So this is the pandemic impact in different aspects, and what we as a research scholars or legal scholars can try to help reviving the industry, whatever the industry, maybe any kind of industry. But there are certain advice we can give, or when you give advice, this kind of questions comes. So then I'm going to touch the last part, that is picking up certain contemporary international issues, particularly when I say contemporary international issues or international law. Friends, before talking about various contemporary issues, we should look at some background. Okay, here domestic and international environment are different legal order. Okay, so domestic legal order completely different with the international legal order, or domestic legal environment and international legal environment. Domestic legal environment are countries. Today, more than 200 countries, all these. So every country has their own legal setup, regulated through institutions, set up institutions. Our domestic laws are regulated through a well-established institutional mechanism. What are the institutions? When I say you have a legislature to legislate, executive to implement, judiciary to interpret, all this. But in international legal order, you don't have these things. International legal order is weak. International law or international legal order is, between sovereign states. The problem with the execution of various international law-related questions I'm going to talk about here is we have to have this background. So, okay, domestic legal order. Comparing, I'm using the word compare to domestic legal order. International legal order is a weak, unenforceable, problematic. Why? Because international law. What is international law? International law regulates the relation between states, relation among states. International law is interstate law, intrastate law. Sovereignty is important. The moment when you say I'm a sovereign country, how are you going to enforce? So these kind of lot of questions comes, friends. That's why I'm just cautioning you that when we discuss any international issues, please make sure that international legal environment has certain inherent difficulties, problems, weaknesses, because we are dealing with the sovereign states. So that is what you have to keep in mind when you deal with international issue. Not unlike domestic, because domestic you have executive, judiciary, police, all these things are there. It is lacking in international. That's why international legal order or enforcement of international law or various branches of international law, we have a lots and lots of problems. So because of the inherent weaknesses in the system itself, vertical or horizontal systems we call it. Everybody is equal in the international context. Everybody is a sovereign state. So those are negatives. That's why I'm cautioning you, I'm appealing you to that. Please, when you look at international issues, keep this in mind that international law has a certain problems, because this is a between. Normally we are lawyers, law scholars. You know that law means enforceability. It's above everybody, and whatever Supreme Court or whatever law says, we have to follow. But unfortunately, this law, international law or international related, it is not between. It is not above. There is no supranational authority. Everybody is a sovereign. So that is where the limitations comes. Please keep this in mind, the limitations, when we discussed international legal order. Okay. So of course, in domestic, I said, because execution is okay, because of institutions are there, but still, international legal order also implement, or international law implementation is there. I'm not saying that international law we don't enforce at all. We will enforce international also, but you have to be evolve different approaches, different methodologies, different segments to implement international law. For example, here, if you look at my slides, of course, they have a lot of meaning. Here, approaches to domestic law: coercion, compulsion, danda. Okay, anybody violates, you have a punishment, those. But on the other hand, international law does not have these things. International legal order, if you as a legal advisor, or if you are a student of international law, what could be your approach? Your approach should be cooperation, coordination, consensus, convincing. All these new approaches we can apply for effective implementation, for effective enforcement. Of course, enforcement is a problem. Okay, but still enforcement is happening. How can you enforce this? Convincing. You have to convince the global society or other country that this treaty is good if you accept, if you ratify, if you sign. Those kinds of things you have to. That's why I am putting here different approaches. That is, the cooperation is important, coordination is important, convince is important. But so far we are following these methodology for effective implementation of international legal order. My question is that, is these approaches are going to continue part of the pandemic? That is or whatever the legal order we are maintaining, are we going to continue, or do we need to have a different legal order? Again, it's a researchable question. I don't have answer, but I am just raising the issue. So this is the domestic international legal environment. Of course, the moment when you say domestic legal environment, one more problem with the international law or international order is that international law does not have its own machinery to implement. Again, international law has to depend on the countries. So that's why is a challenge. Implementation of international law is a challenge. Though you convince, you cooperate, all those things, but ultimately who has to do? It is the states which have to. States, I mean countries, which have to accept, which have to abide, which have to implement these things. So that's why here just maybe 2-3 minutes because I'm going to touch certain issues, depend on my time. But this, maybe next 5 minutes talk is very much relevant to any contemporary issue you take up. So here I am going to put, two important questions: domestic implementation of international law, whether it's international air law or space law, or human rights law, humanitarian law, refugee law, trade law, any branch of international law. This is the common. So what is that common? How we implement those international laws. Okay. So here 2 questions. One is why. You may ask a question. We, India as a sovereign country, or America is a developed country, why we have to implement international law? Okay, first question. Then second question is how we implement. So first is why implementation. Yes, friends, though we are sovereign states, every country is a sovereign country, but there are certain necessities, certain compelling reasons. Today, we have to be part of the global society. For example, I'm just giving example only, changing notion of sovereignty. Earlier countries used to give too much importance to the political sovereignty, because most of the countries were under colonial rule. After that, they got independence. Today, transformation, shift from political sovereignty to economic sovereignty. Today, countries wants development. In lighter way, I always say that all isms have gone: socialism, communalism, capitalism. Today, countries are individuals believing in only one ism. What is that? It is the materialism. It is the developmentism. It is the develop every country. In this process, countries are foregoing their ideologies. What they followed, they are not bothering. Today, the ideology which most of the countries are following is the development. They have to be part of the global society. I'll give you examples of these. But today, one important thing, changing from political to economic sovereignty. Of course, other reason, I'm giving an examples that why you have to be part of the international or global society. Globalization. Friends, globalization which has impacted. Globalization of different kind. Globalization of economic globalization, cultural, political, all those we have seen. But globalization has good and bad. Globalization has solved global problems which never thought of. But globalization has more negative. Today, globalization made independent states to interdependent. Today, we are living in an interdependent world. Okay, interdependence is the order of the day. How mighty you are, how powerful you are, how big you are, it won't matter. You have to depend on other country. Dependence is the order of that. That's why we have to follow international norms. Other examples I can give: lawmakers to law takers. Today, lot of law we are taking from international treaties. Earlier, of course, you may ask questions: is it not that? Is it not our parliament is making law? Yes, friends, parliament has duty to make law, but lot of law parliament is taking from international treaties. That is what I want to. So lawmakers to law takers. And today, for example, you take certain emerging laws. Today, if you look at Indian IP law, Indian trade law, do we have our own law? I always get a question. Do we have our own domestic law? Today, whatever the IP you have, all those 7-8 important legislations pertaining to patent, trademarks, industrial designs, all those, we borrowed from the TRIPS or international treaty. So that is is it good or bad? Different debatable issue. I'm not going to that. Why, how, being a sovereign country, is it required? Those, but these are all which are happening, which are making states to be part of the global society. So role of states, regulator to facilitators. Today, earlier we used to regulate a lot. Today we are facilitating. Okay, come invest, I'll give everything. This kind of things. That's why status of international law is changing from weak, unenforceable to today enforceable law. Okay, WTO, all those best examples. So these are some of the reasons. Just only some are few examples I gave. Some of the reasons why domestic implementation is required. Implementation of any branch or any aspect of international law. So then question comes, how we implement. Okay, how states implement is a big question mark, because they are sovereign states. Where question comes that is international law, domestic law same or different? Again, there are theories. Okay, few authors, jurists says that international law and internal law same. That's called monism. Okay, only one law, application will be different. Then few countries follows, but majority of the countries, including India, today we follow dualism. We believe that, I means India believes that international law and domestic law, two different distinct bodies. If at all international has to be implemented in the domestic level or India, we have to have a transformation. That is what third point, transformation or specific adoption. We have to adapt those, we have to transform those international law principles into domestic law. And we have around 15 to 20 important legislations which we have. Then delegation theory, of course, it is also supports monism. Means when you go and participate, you have to automatically implement. Then there is a theory called harmonization. Okay, so what I'm trying to put here is that there are two views on the domestic implementation. Some says that automatic implementation. Most of the countries, majority of the countries, including India, we believe that no implementation of international has to be consented by, to adopted by state parliament or whatever. So that is the thing, and this is most difficult also. Okay, but question comes, domestic enforcement of international law. Again, friends, why I'm referring this is a common to all the branches. So if you say that 15, 20 are contemporary, any contemporary international law, this slide will help you. This slide will get you whatever the branch. To again aviation to space to defense, any technology, human rights, humanitarian, refugee. But how India implements international law? Once you have an understanding about international law, then easy to understand the different facets, different emerging areas. So that's why here I am just going to talk about few minutes domestic implementation of international law in India. So just now I told you that we follow dualism or transformation adoption theory. So of course, international law has come in core aspect today. International law, every aspect, international law is impacting social life, economic life, political, cultural, all those. India's interest in international law has always been profound progress development. This is reflected in why international law assuming a lot of importance in the interdependent world is, if you look at the recent judgments of the Supreme Court of India or various high courts, how these international law issues dealt by this Indian judiciary, whether it's a Supreme Court or High Court, is giving importance to the various international issues, which reflected recent judgments particularly. Okay, that is one. So coming to the how we implement, where to start, how to understand this domestic implementation. Yes, friends, we have to start with the constitution. Okay, though I'm not a constitutional expert, but constitution is important to begin anything, because you all know that constitution is a basic law, supreme law. All laws comes from originates from the constitution. It's being a supreme law, and of course, confusion with the Indian constitution is that it has more than 400 articles, many parts, and all those. I'm not going to that. But if you look at all those 400 plus articles, there are certain articles which have something to do with international law. That's why I'm referring here constitution. So if you look at all entire constitution, all we can put it in three important aspects of international law related constitutional provisions. For example, we can look at one is constitutional provisions. Of course, how we implement, here I mentioned pre-constitution, whatever British we used to practice, we used to practice because India was a part of the British India. But after independence, we have our own constitution we adopted, and now we are celebrating 75 years of constitution also. Though constitution, we have certain provisions dealing with international issues, particularly here. All to simplify, to put in 3-4 minutes I put here, otherwise we can devote much time. I'm not going to do that. Constitutional provisions relating to international law, emerging issues of international law. One we can put a general, particularly when I say one category is general category, Article 51. You all know that Article 51 is part of the Part 4th of the Constitution. Part 4th is the Constitution is directive principles. It is the directive from the Constitution to the state that you have to do or implement international law. So that's why Article 51 says that state shall endeavor for promotion of international peace and security. It has to follow international treaties, international customary practices, peaceful settlement of disputes, all those. So one provision talking about international law or international implementation. Then second, the executive provisions. If you look at, friends, Indian executive, what constitute Indian executive? What do you mean by Indian executive? Indian executive constitute President of India, Prime Minister, Council of Ministers, bureaucracy, whatever. They have certain powers. Powers for what? To make and implement international law. Friends, again, making international law is different from the implementation of international law. So executive, Indian executive has been given certain powers based on Article 53, 73 and 77 of the Constitution to make and implement international law issues. Of course, Indian executive exceeded its limits sometime where a lot of issues, problems came, particularly issues like WTO all. But yes, executive has been given certain powers. Where from these powers came? Through Constitution, or Constitution has given certain powers making and implementing international law issues. But ultimately, the major part of the implementation of international lies with the Parliament. We in India follow the parliamentary form of democracy. Who is the supreme in the parliamentary form of democracy? People, or people's representative of Parliament. So Parliament has a exclusive power making and implementing various international treaties based on Article 245, 246, 248, 253, 360, 372, all those. So Parliament has a power to make and implementing international law, and this is what you can. So last 5 minutes discussion you can apply to any emerging branch of international law. That's why I just put international law and then extending that to different facets of international law, different emerging issues of international. Then come to the some issues. I don't know how much time I have. Can anybody help me? How much time I have? Whether
Sir, Yes, sir. Sir, you are having time till 8 o'clock, sir, along with the question and answers till 8 o'clock. We started at 6:30, sir.
Okay,
So
no problem.
1.5 hour lecture. Yes, sir. Thank you, sir.
Okay. So now I will go to the core issues. Okay, core issues when I say pertaining to pandemic, and how pandemic is uh, undergoing a lot of transformation in international law issues. I can start with the traditional concept like state responsibility. Okay, how the state responsibility we are looking, particularly context of China and other things. What is the state responsibility? Under international law, states have a legal responsibility both towards the state and also individuals. If a state, this is the responsibility. If a state violates international law, it is responsible, to immediately seize unlawful conduct or offer appropriate guarantee that will not repeat illegal action. Okay, if somebody or some state is doing anything damaging, then it has to stop. It has to stop that unlawful conduct, or it has to offer appropriate guarantee, or this thing. If they fail to do, then your responsibility comes. That's why here it says states also have a responsibility to make full reparation for the injuries caused, including both material and moral damages. Even sometimes they can also are responsible to make reparations or damages, those things in the international context if they harm. Apart from these, individual rights are also violated by some states and also by non-state actors. Friends, here I have to just make clarification saying that in the eyes of international law, individual is not responsible. Individual is not subject. I don't know whether you have heard something called subject object. Okay, what is the subject? Subject is an entity which is endowed by rights and obligations under international law. Who has endowed these rights and obligations? It's the states, international organizations mainly. But today, because of certain human rights development, other individual is also becoming part of international law, but not true. So ultimately, it is the states, it is the international organizations. If anybody has any problem, individuals can take up that problem through states. State has to represent international law. That's why if something happened, here, for example, foreigner came here or something happened to that foreigner, it is not that individual is responsible to that state. It is the Indian state is responsible because state is the having a legal or subject entity. So this is what state responsibility happens. So it is the responsibility of state under international law to protect or to take immediate action to solve these problems. Okay, state responsibility, the possibility of holding China accountable for violation of the provisions of international health regulations 2005. This is what we are going to look at, because it is the duty of states to inform any pandemic or any this thing. They should inform to the WHO or global society. But it happened in November, December, but 2 months China did not inform to about this. So that's why United States and even in India also, lot of discussion happened that China violated the international norms, not informing to the global society. It's a violation of WHO rules, international health rules, all those. Okay, that is state responsibility. China should make responsible. So of course here further elaboration. In the wake of these coronavirus, reoccurring questions have been raised about legal responsibility of China in continuation of my talk. Role spread by the virus. Okay, as the virus continue to havoc, they have not informed, they have not given any precautions. To do that, can China be tried in domestic courts? That is the question. Of course, that there is a limitations our immunity of states. So China gets under that. We can't. Though in the United States and India, some suits were filed, but though they are not entertained because China is a sovereign state and it has a responsibility. Of course, we can take up these issues in the international fora because we have International Court of Justice or other modes, but domestic courts does not have file a suit against the particular states. What we call is exhaustion of local remedies and those. So they can't. Can China be held responsible under international law? No, because of again these privileges, immunities. Then practical difficulties in proving China are culpable because it is not, and all those health regulations, Article 6 and 7 of WHO, all those. Because what it says, like I mentioned you, within 24 hours, it says HR obligates states to event occurring within the territory and notify WHO within 24 hours of any event, including unexpected or unusual public health event. So that is what the mandate. within its state responsible, or state has to inform to the WHO, because this is relating to health. But otherwise, every state is responsible. It should not allow any untoward events or any things which against the state. For example, a famous case, that is Curfew Channel case, and we have many cases also. But here China failed. That is what here we can look at. Of course, WHO rules and other things. I'm not going to, but these are certain pertinent questions relating to. Here it suggested that as an advisory opinion, or some states can go to ICJR advisory opinion. Of course, advisory opinion only WHO can go, not others. States, you have a compulsory jurisdiction. Then international organization, they can seek advisory opinion. So that's, then this is one area which a lot of discussion happening last 4 or 5 months. I thought I will just discuss with you. Then other important area which I am going to look at is international air law. Okay, in one slide I will give you very quick overview. International air law. What is international air law? I mentioned international law. Okay, body of rules governing the regulation between states. But here I can say that international air law is body of rules governing the use of airspace. Friends, airspace is different from outer space. Of course, is there any technical these things? But no, here this question is there for last 60 years in the United Nations Committee on Peaceful Uses of where airspace ends, outer space big and all. I'm not going to do that, but up to flights can fly what we call air zone or aviation regulations. Beyond that, satellites, then space. So what is the air law? Body of rules governing the use of airspace. Okay, how to understand it? Because I have to focus more on the impact of COVID on air law or aviation industry. So, but before talking about the COVID impact, you should also know what is the air law, how it is impacting, how it is regulating. So very quick, I'll give you whole air law can be. Of course, I am studying air law for last 30 years. Still, I am a student. Okay, I am learning, but I can give you very quick or just points. I can give you how to understand international air law in a quick manner or in 5 minutes. I can tell you, friends, understanding 3 P's. What I call is PPP. PPP. Nowadays, PPP used in public-private partnership. It is for airports, other things. I'm not talking about that PPP. I'm talking about 3 important areas of international air law. That is called public air law, private air law, penal air law. So whole international air law can be summed up in understanding of public, private, penal air laws. What is public air law? What it deals? What I call public air law deals with Chicago regime. Chicago regime deals with general and technical. I told in my beginning class how technology is impacting aviation law. So that's where. So Chicago regime are the general and technical regulations. Why I call regime is related conventions you can put together to easy understand. That's why I said Chicago regime consisting of the Chicago Convention and other conventions treaties dealing with the general and technical aspects of international civil aviation. For example, you have a Paris Convention. Then we have for example, friends, Paris Convention 1903. I mentioned, in the technology part, what I said, invention of aircraft by Wright brothers in 1903. You see, even at the same time, international community talk about the regulation. Flights have a cross-border in nature. How to regulate? What kind of regulatory regime we can bring? They have a meeting way back immediately after the Wright brothers invented aircraft. Later on, of course, Paris Convention 1910, 1919, development happened actually. After First World War, in the First World War, aircraft were used, for good, bad, all those, based on the, experience of, World War. Then they came out with, Paris Convention for regulation of aerial navigation, or Paris Convention. Then, of course, again, Second World War. And Second World War, again, the aviation or aircraft was used, misused for destructive, constructive purposes. Then learning based on the experience of Second World War, the Chicago Convention drafted. And today, the moment when you say aviation or air law, it is the Chicago Convention, which is the charter, which is the Bible, which is the law, which deals with the technical and aviation regulations. Chicago Convention. We have also ICAO. Part of that, there is an organization called International Civil Aviation Organization, which takes care of all the technology, general, other aspects of air law. So this is what I call first PR, public air law. because public air law deals with the intergovernmental organizations and between states. So that is Chicago. Then next important aspect is second P, private air law. In international law, you have public air law, private air law. Public air law deals with the states, private air law deals with the individuals, different. So this is because liability on individual. Something goes wrong, how to pay liability for whom? Individuals. So that's why this is called private air law or Warsaw system. Again, Warsaw, what is a Warsaw system? Warsaw system deals with the liability. Our Warsaw system consisting of Warsaw Convention 1929 and other conventions and protocol. You all know that the difference between convention and protocol. So conventions and protocols dealing with the liability of civilization. It traveled 1929 to today. We have around 10 important treaties. That's called Warsaw Convention 1929, Hague Protocol 1955, then Montreal Convention, then Montreal Convention of 1919, Beijing Convention. There are lots of international conventions which deal with the liability regime. That is second PR, private air law. Then third one is public air law, private air law, penal air law or criminal air law. That deals with the two aspects of air law, safety and security. Okay, what is the safety? What is the security? Is there any difference between that? Air safety is actually technical thing. Safety is nothing but minimizing the dangers caused by aviation activity. So this is a technical thing. Security is dealing with the men and cargo. Okay, damage to the cargo or delay to cargo or death of passenger, all those. That's why we call this is relating to men and cargo. We have international conventions dealing with the safety, particularly Chicago Convention, various annexes and all those. Security, we have also international conventions dealing with the Tokyo Convention 1963, Hague Convention 1970, Montreal Convention 71, Montreal Protocol 1988. We have a plastic explosives. All these very, very established legal regime is there on third P or what we call penal air law, safety, security. So this is generally in 5 minutes. Of course, I summed up. But friends, this is a long way to go. But I just give an idea. But next question comes: how this we implemented international air law in India. Like I told, general international law. Similarly, every branch we have to look at how we implementing or how we are implementing. So domestic air law in India, of course, friends, why India is a party to all important treaties which I referred. Around 30 important international treaties which part of the international air law, and most of the treaties India is signed or ratified all these treaties. That's why India is incorporated very many legislations for implementing international air law. We have a Aircraft Act, then we have a Aircraft Rules, Carriage by Air Act, Tokyo Convention Act, all these. There are 5-6 important legislations which to implement international aviation treaties. So this is what I can say international air law or legal regime relating to international air law and how we today we have international air law. How we implement, we have two levels. One is legislations and organizations. We have these legislations from 1934. We have a 1911 Aircraft Act, 1934 Aircraft Act, 1937 Aircraft Rules, Public Health Rules. Like from 1911, of course, we repeat that, and today we are having 1934 Act, still important. That is the, I am using the word, that is the important law. Even till today, India domestic air law means it is the Aircraft Act 1934. Of course, we have other legislations also, but that is the base legislation or important legislation. So then we have other acts, including the Tokyo Convention Act 1975, Carriage by Air Act 1992, of course 72, now replaced by again 2009 after India acceded to Montreal Convention also. So we have a international air law, domestic air law, and a lot of developments are happening. I know India, earlier it was, to put in two sentences, when we got independence, it was like 8-9 airlines, private airlines were there. After that, India actually nationalized and made two companies of Air India for international and domestic Indian Airlines for domestic. Then after from 1953 to 1994, we were under that corporatization or government control, under government control. After 1994, because of liberalization all, so India again liberalized, and today we have more private airlines also. So it's a checkered history of Indian airline. So, but coming to the point, what kind of issues the aviation is posing, or aviation industry is suffering? Yes, I told earlier, and now also I'm telling you, one of the industries that coronavirus pandemic is threatening is the airline industry or aviation. Flights are almost empty. Flight schedules have been drastically reduced. The warnings from the trade associations are coming that industry is not going to come up very soon. These kind of things, and very many pertinent questions for research. I can tell you, for example, what kind of research we can do when we have to bring aviation to the normal. Yes, these questions are posed by industry. For example, rental payments, issues such as rental payments, force majeure clause, rental holidays, leasing, particularly leasing agreements, they have a problems. Airport slots, passenger rights, because a lot of cancellations happen. They want to get their refund, and the litigation is there in the courts. Particularly April, May, a lot of litigation happened because they cancelled and they are not refunding. They want refund, but industry says that we don't have money. Those kinds of issues the aviation industry is facing. Particularly last 4-5 months. Pricing, financial arrangement, restructuring, import duties. All these are all pertinent questions which are part of the aviation industry because of the COVID impact. And international organizations, like I mentioned, ICAO is the organization which deals with the aviation, is trying hard to bring normalcy in international aviation industry, urging governments, not only ICAO but ACI. ACI means Airport Council International, which represents all 5,000 plus airports. Okay, IATA represents all airlines. Like all these international bodies are trying to actually revamp the aviation industry, urging the state governments, state I means countries, to bring and help finances and other things. So COVID and the airports and airlines, not only airlines but airports also. I've jotted down certain issues. These are all pandemic issues which have a lot to do. If somebody can do research, I think it takes months, years together. So there's a lot of pertinent issues which the COVIDization is posing. I am now using the word. Earlier we used to talk about globalization, liberalization, privatization, deregulation in the aviation industry, but now I am talking about the COVIDization. COVIDization is going to have a next 1 or 2 decades which have a lot of impact. What we have seen globalization, its impact. Now I am predicting that COVIDization is going to have that kind of impact on the aviation industry or aerospace industry, friends. So this is a very brief about the what is the international air law, how international air law can be regulated, and then what is the recourse we have. Similarly, any issue, because when you want to stop, then please stop. Otherwise, I can go on talking, but I am giving you the ideas. Okay, one is air law, other one is human rights. This is a lot of human rights were violated. You all know that human rights. So, but what is a human rights? One has to start with understanding the concept. That's why I said what is air law. Similarly, now I am saying that what is the human rights law? What do you mean by? Of course, friends, if you look at the Protection of Human Rights Act, particularly Article 2(1)(d) says human rights means the rights relating to life, liberty, equality, and dignity of individuals. These are all 4 important rights. What is that? Life, liberty, equality, and dignity of the individual, guaranteed by the Constitution, embodied international conventions, and enforced by courts in India. If you look at these 4 lines, you can understand entire international human rights law or human rights law. It says first is what kind of rights we have. Rights, life, liberty, equality, and dignity. These are the rights. Who guarantees this? It is Indian Constitution, which guaranteed by the Constitution. Okay, where these rights we borrowed. Indian Constitution also borrowed these rights. Where from we borrowed? We borrowed from international covenants, what we call covenants or treaties, whatever. So international covenants. Here, when you look at international covenants, we have hard and soft law. I will explain that. But a lot of international treaties. These rights we borrowed from the international treaties, which are guaranteed by the Constitution, which are enforced to courts, whether it's the Supreme Court of India, High Courts, and all those. So this is very important, very crisp definition, but gives the entire understanding the concept of human rights. That's why I just read for your benefit. Okay, human rights means rights relating to 4 aspects: life, liberty, equality, and dignity, guaranteed by the Constitution, embodied in international covenant, enforced by courts in India. So how these international human rights law evolved? Of course, if I have time, I can go on talking, but we don't have. I will sum up. it is not that we are talking about human rights because of COVID or COVIDization, but human rights were there, are there, is going to be there. For example, approaches to human rights start from natural law to philosophical law to sociological, positivist, Marxist, all those. There are views on how human rights can be executed or implemented. Marxist theory, actually, other theories, human rights are part of nature, social, part of society, all those. Marxist theory on human rights says that base superstructure theory, base determines superstructure. Those who are possessing means of production, okay, they control the human rights. So that is what Marxist approach. Of course, Western approach, when I say Western approach, we can look at from 1215 Magna Carta, French Revolution, American Declaration of Independence. All these are all part of international human rights. Of course, later on, internationalization of human rights began with the United Nations Charter, particularly here. Of course, here I put all these rights. We can sum up in 2 minutes. Is that international human rights law can understood the following 3 important areas. Civil and political rights are what we call first generation rights. Social, economic, cultural rights, what we call second generation. Today we call third generation. Group rights, women rights, children rights, minority rights, labor rights, all this. And fourth generation, now we are talking about environment, all those. So these are all different kinds of our classification of human rights. Where from these rights came? Of course, we have soft law, hard law. Soft law means non-binding instruments. Universal Declaration of Human Rights is the best example, which has 30 articles, and each article is very important, to understand. And then we have very many treaties. Okay, treaties of international in nature and also regional treaties. When I say international treaties, we have International Covenant on Economic, Social, Cultural Rights. International Covenant on Civil and Political Rights, International Covenant on Economic, Social, Cultural Rights, and then we have very many group rights. Okay, but today, lot of human rights are regulated by United Nations through various organs of United Nations, specialized agencies of United Nations, all those. Or to put it in summary, entire international human rights can be understood by looking at 5 important treaties or declarations. First, UDHR, ICCPR, ICSCR, and optional protocol to the civil and political rights. One deals with the individual rights. Individual can go to international access. Second protocol is abolition of death penalty. A lot of debates are going on. So this is International Bill of Human Rights. Of course, UDHR important. How domestic implementation. We have a of course we have the Protection of Human Rights Act 1993, which created national commission. Then we have a state commissions and all those. That's of course. What is the impact of pandemic? I've mentioned all these disasters creating violation of human rights, migration of labor, health related rights, all those. Refugee, lots of now refugee, because I had to sum up, friends. The refugee also, basically Refugee Convention 1951 is important, but we have how the impact of these international refugee issues because of COVID is migration, labor, all there's a lot of refugee challenges, refugee problems. We have health regulations, challenges to health regulations, employability, labor laws. Lot of environment is again lot of issues relating to environment, intellectual property. Okay, IP is also very important. International IP, then domestic IP. So you can quickly. Then COVID impact, what is the impact? Today, global society is working for the, invention of drugs, injection, all those. How, we are going to protect that, what kind of rights, whether it's a patent or, all those things is a big, issue. International trade, WTO is also have a lot of impact on the trade and, investments. All these are all have a lot of implications. I just run through.
Sir, there are a few questions that have been posted in the chat box by the participants, sir. Sir, first question by Ramya Satyam, sir.
Okay.
For law to be on par with the speed of technological advancement, is there something we can do in the ground root level to expedite the execution of modern legal philosophies?
Okay. That is what, not the grassroots level, but it has, states have to take up these issues. Who will make the law? It is the parliament. Okay, a lot of these technology are impacting. For example, not only many areas. For example, I can give you, we are so backward in bringing the law. I can tell you one important example is we don't have space law today. You know, friends, you know, India is one of the, you know, our 4 or 5 countries of the space technology. We are doing wonders in space technology, moon and, you know, Mangalyaan, all those, you know, lot of developments. But unfortunately, I can tell you that we don't have a space law. Why we don't have? Actually, as a research scholar, as a, you know, again, my specialization is air and space law. Last 30 years of my writing, lot of my writings or articles or, you know, papers, I am devoting on that we need space law. Why we need? Because we moved from scientific phase to commercial phase. Now we are buying, selling, you know, lot of transactions are happening, business is involved, litigation is going to come, but we don't have law. That is first. Why you want? Because business is happening, or phase from technology phase to commercial phase. So then second thing, very good question she asked. I am, you know, explaining, giving example of space. Second thing is, friends, you know, judge role is to interpret law, not make law. Okay, and you know, if you have a act or you have a legislation, he will interpret, he will give judgment. Today we don't have a space law. How they are going to give judgments? And I'm not saying that, you know, judges, they have a knowledgeable persons, but they are not having a domain knowledge. Okay, they are not experts in space law, so they may go wrong. That's why it is the time, not only one, but I am giving example. This is so important area. India is earning millions and billions of rupees through, you know, satellite launching, remote sensing, all those, and we involved $1 billion business, but we don't have law. So it is the law, yes, not grassroots. It is the, you know, of course, grassroots. We all, you know, like scholars, we can pressurize government. I am doing for last 30 years. There is a need for space law, and I am, you know, working on that. Yes, we all can do, but it is ultimately, it is the government, sovereign government can take the decision to make law. In absence of law, we have a problem. We have a divorce case and other things also. That's why need for law, absence of law, because India is going to play important role. I think, you know, in that context, yes, it is the government which should take appropriate, you know, direction, action, and they should bring out not only the space law I gave example, but any emerging law. Okay.
Question from one Ms. Shailja Khosla. Sir, do you see international law taking on municipal law, or municipal law is superior during COVID?
Okay, very good. So generally, you know, friend, actually it is the domestic law which prevails over international law generally. So if you look at, you know, even Indian practice also, very good question. So normally, if as long as there is no problem, no problem. Question is that like this: if international norms are conflicting with the domestic law, which prevails over which? Yes, it is the domestic law which prevails over international law. And we have like 70 to 75% of the judgments, whether it is the Supreme Court of India or High Courts, have given this kind of opinion. So including the COVID also. We practice, you know, what we were, you know, doing in all these years. Similarly, if you take that example, it is the Indian law. That's why I said, you know, it is a two different distinct bodies. If at all international law has to be applied in the domestic context, India has to have enabling legislation. Or if you go to court, court will see that do we have a law. Based on that law, they will give. If conflict, then they will give judgment based on Indian law rather than the international law. Majority of the cases. I'm not saying all the cases, but I can tell you that 70 to 80% of the judgments pronounced by the Indian judiciary, which reflects that Indian law is supreme over international law, including the COVID. Of course, COVID is just, you know, it happened.
Next question, sir, from one Miss Arra Rajalakshmi. Under international law, whether China can be made responsible for the pandemic situation?
Yes, that is what Rajalakshmi. I was, you know, I was showing you 3-4 slides. State responsibility, because, you know, Article 7, 6, and 7 of WHO rules, which, you know, mandates that if you are a member, you have to intimate to the WHO as well as other countries. China actually did not up to 2 months. It happened in November, right, till December. It could not inform to the WHO or global society. That point, yes, that, you know, point, most of the countries, including India, some suits are happy, say that China should be made responsible because it's, you know, deleted its duty to inform to the international organizations like WHO. But I also told that, you know, we have a problem because state immunities. Every state is a sovereign state. They have certain, you know, immunities. Under that, China can't.
Actually, continue just about it.
Yes. China, we can't, claim China, but we can go to the International Court of Justice or not the international, doors of ICJ or other forums, but not even some states in the United States also filed, but that's what we can't. We can't ask sovereign country to come and appear. Those kind of limitations are there because of state sovereignty, immunities, privileges of sovereign states.
Sir, next question is related. Sir, what mode of reparation is appropriate in case China is held accountable? If compensation, is it feasible to pay or compensate every state?
No, this is a very, of course, theoretical question. Compensation, they are not going to pay, or if we ask a compensation, it's a very problem actually. Friends, you have to look at the background actually. So one general saying, I'll explain you also. When it comes to international law, effective enforcement comes when developed or least developed country. Now China is a powerful country. China is part of the P5, all those. So it is highly, I don't think, it is, China can make or reparation or monetary, all those compensation, China can give. And I don't think this is a valid in the context of international. Question is valid, but paying the reparation to this is not there under the provisions. Of course, there are certain, cases like curfew channel case, all those, they paid compensation, if they violate. But here, it is not, I don't think, that thing comes, paying compensation. I don't see as a, this thing. But if it all comes, of course, damage either through monetary or again, whom will you pay? You have to pay to the global society, all the 200 plus countries. So
yes,
I don't know,
yes,
but
sir.
that is the general, this thing. Yes.
Sir, next question, sir, from one Mr. Prabhakar Rao. Sir, please explain the role and responsibilities of financial institution with respect to human rights.
Okay, what financial institutions, for example, which financial? For example, we have a global financial institutions like IMF, IBRD, GATT, WTO. Whether those financial institutions are, we are talking about the financial institutions of domestic. I don't know. I didn't get, but what financial they can pay. I don't know. I didn't get friend, but they don't have. It's the governments. Okay, if you are to pay compensation, not the financial institution. Normally, the government are concerned organs of government. Something went wrong in aviation, state can pay, or health related, all those. So it is generally, it is the state which can pay, but I don't think, any organs of or subset of departments can pay. So it's the state, I think, government can pay, but not, that particular thing. I think so.
Yes, sir. Sir, next question, sir, from Dr. Yedla Prabhakar. Respected sir, what is the impact of COVID-19 pandemic on the society relating to international scenario globalization? Whether imposing lockdown is legal or illegal?
Of course, imposing, lockdown is it is a sovereign prerogative of the state. Okay, India imposed, lockdown because India saw that, to prevent spreading, we took decision. But globalization, of course, it is a general thing, I don't see. But I told friend, actually, it is the governments or it's the states which have power, okay, to act or not act or do or, not to do all those, these things. Globalization context, actually, globalization where, for example, part of the globalization, you have IMF, IBRD, all those, that. But I don't see, that, they have any say except the states. It is the states have to take decision, but nobody else can. So that's general, rule in international law, particularly international trade. Of course, they can bring, if it is international thing, WTO can look into that if, some damage is happened, if it is in the WTO purview. Of course, that kind of things, that WTO they can go to WTO dispute settlement, that.
Sir, next question from one Mr. Badal Chatterjee. Have we academicians done enough to push for new laws? Are the academicians doing enough, communicating enough with solutions with the legislators? How can academicians and researchers help fill the void between technological advances and outdated laws?
Okay, we as a scholars, it's a responsibility. Friends, we as a scholars or researchers, our duty is to take that issue, write about that, propagate about that, look at the consequences about that, we can do to that extent. Somebody has to bring to the notice of governments. Are so today, earlier civil society, including we all comes as a part of the civil society. I can say civil society role was negligible. They never bothered about the civil society actions or civil society reactions. But today, most of the law, whether it is international law, domestic law, when they make law, they will see that what is going to be the impact, or what is going to be the reaction of society. That kind of thinking is came. So that is, I think it's a good achievement. What we all can do is that we have to, first thing is that we have to see that there are issues because of this law is not catching. There are this much of laws we are going to losing all those. So we have to brought to the notice of the authorities. We have to pressurize that authorities. But ultimately, again, states, they have to take so the legislation part I'm talking about. We as a, yes, we have a responsibility. Here I reminded one, recent past, if you look at, there is a CSR. We all know that. What is that CSR? Corporate social responsibility. But recent past, I'm also talking about, writing about ASR. You know what is the ASR? Can anybody tell what is the ASR? ASR means academic social responsibility. That's called university social or academic. If you have a institution, for example, if NALSAR is the best or second best law school, what is my social responsibility? I have to bring these issues to the purview of the concern. So, and I can tell you, friends, I don't know whether how far I can correlate, but today, being the best law school in the country, we have done lots of legislation. We are helping. Of course, we don't make law, but we help in making law. We give drafts. Today we have done, whether it's a land rights or marketing or environment, municipality act, NALSAR has done a lot of legislations. I feel that that is the responsibility of civil society or academic institutions. Definitely, we can feel, we can help the government if they ask. So it is the best example is NALSAR. Yes, I can confidently tell that NALSAR has done a lot of legislations, particularly for Telangana state. So similarly, we can put any gap is there, institutions can help. Unfortunately, today we are forgetting our duties. I raised certain issue here. Of course, we are not going to give answer to all those, but at least we as a scholars, we can predict, we can do research. So yes, definitely everybody has a responsibility, including you, me, all. So that I think that thinking should come and we pressurize governments. We can succeed.
Sir, next question, sir, from Satyendra Kumar Sharma. Sir, in case of South China Sea, Beijing rejected tribunal's ruling in 2016.
Yes.
China said it will not accept a ruling against it in a key international legal case over strategic reefs and tolls that Beijing claims would give it control over disputed waters of South China Sea. China is still claiming over South China Sea, rejecting international tribunal ruling. Who will enforce the tribunal's ruling?
Yes, very, very good and very, this. I told, before that, when it comes international, I said there are, certain judgments which are enforceable if it is a small or poor or weak country. But China, I told that is a powerful country. I'm not saying that, they should violate. Today, friends, international law, normally it is a consented. How international law operates? Because, China was part of ICJ. China was part of all the law of sea. There is a, how these, issues comes, when when I had to discuss, this South Sea China, you had to go to the background. These are, what is that background is two levels. One is coastal states are trying to extend their jurisdiction. Earlier it was 12 nautical, 3 nauticals, 6 nautical. Today we have a 12 nautical miles, territorial waters, exclusive economic zone. Then we have a, high seas. Okay. When it comes, beyond our jurisdiction, there are limitations. Okay. That what we call global commons. Okay. Where this issue happened. Okay, South China is, sea belongs to everybody. It is not you, me. It is not coming under the territorial jurisdiction of particular country. It is beyond. That's why what we call global commons. I'll tell you here, just to explain, there are 3 important concepts. When this kind of questions comes, global commons, common concerns of mankind, common heritage of mankind. Global commons are outer space or, law of the sea, all law of the sea or airspace, all. This belongs to everybody. So everybody has a right over that. What kind of rights you have for making, experiments, all those. But even if you go behind, you have a duty to pay something. Okay, those kinds of things applicable as of now. But violation, the friend is talking about, asking about the South China Tribunal, judgment China rejected. Yes, China rejected because China is a powerful country. We don't have, like, that's why I said, these are all limitations. We don't have a supranational authority which can enforce. You yourself committed to be part of the international law. That's what I say, voluntary consent. The entire international law, whether it's the sea law or South China Chia or anything, friends, one thing you have to remember is that international law operates on the basis of consent. What kind of consent? Voluntary consent. Why voluntary consent? Because there is no supranational authority. You yourself accepted. It is the duty of the China to implement that, but it is overthrown that, and there are lots of issues. But again, ultimately, it's other countries condemn, other countries criticize, you have to do certain things for sake of the rest of the world. But if there are many, not only South China Sea, if you look at history of America and other powerful countries like Nicaragua case, all those, there were instances where countries refused to accept that judgment, and it is true. But recourse, yes. That's why I told in the beginning of my class, please understand that international law has a limitations. International law between sovereign states. International law is voluntary consent by voluntary. So those are limitations, weaknesses, inherent difficulties, deficiencies of international system. So there are problems. I am not going to say that, but it is the international community has to pressurize. Coming to the last part of the question is that, don't we have any answer? Yes, we have answer. What we have to do is, of course, there is Security Council resolutions, all those things, but this is international, applying force is a very rarest of the rare. Actually, continuation of his question, I am asked, can, international community use the force against China? Of course, China, but China again, P5, I told you. But there are instances like where, Security Council can pass resolution when threat to peace, breach of peace, act of aggression. But this is not coming under that. That's why, we can't take that recourse also. But friend, again, I can't give you convincing answer to you, but it is a problem. So China has to implement, but global society, international community has to pressurize, and it has to implement. So there is no other go. Okay, except that. That is the weakness in international system. That's why I said cooperation, coordination, convincing, all these things are applicable. Please, accept, because one refusing of your judgment damage entire international system. Okay, so those are the things we have to take up, friends.
Sir, like time is up, sir. Like, if you allow, there are two more questions, sir.
No problem.
Okay. Thank you so much, sir. Sir, this is from Mr. Bhavani Shankar. The Disabled Persons Act 2016 originated from International Convention 2016. Can an individual sue India for denying equal opportunity in India? What is the procedure?
Okay. So one prospective, retrospective, that is the one principle. Yes, if it is happening in India, they are Indian citizens based on international law, we can sue, but we have to see the locus standi principle, those. So to my knowledge, I didn't get properly that, but if it is a Indian citizen or based on Indian law, there is no bar at all to enforcing that. But if it is international law, then access to direct international law is a problem. So individual can't access international forums or international tribunals or international, because it is individual. International law does not recognize your legal personality. So here individual can't take up that issue, but ultimately it is the Indian state which has to take up that issue. General international law.
Sir, next question by Dr. Bharati. Sir, can we say that COVID pandemic is the failure of WHO, as it did not inform about the incubation period of virus to the countries?
Of course, that is not me, but a lot of criticism is coming against WHO that it has to inform, it has to take measures and all those. To some extent, initial days, if you look at, include not me and you, but it's the people like President Trump, all those, they talk about the inefficiency, difficult problems with the WHO, one-sided WHO, and they threaten to withdraw, and they are doing that. So of course, the general thing is the WTO could not act what's supposed to do that. That is the general impression in my view also. because it is an international body. Well, then 185 countries are parties to that. It is the duty to inform other countries. But here China did not disclose. That is what they said. But it is the duty of WHO to get information from China as a being a member, and it has to inform to the global society. To that extent, yes, it has failed.
Sir, last question, sir.
Yes.
Sir, respected sir, as you have said that the countries are moving towards materialism and not sticking to other ideologies, whether that is a good or bad in the interest of the state or country, sir, also whether the materialism is benefiting the heads or rulers of such countries.
Okay, I said in a lighter way. Okay, but that is materialism. Why is it is now sovereignty, boundaries are becoming meaningless. We are living in a global society, so we had to be part of. So I'll give you an example. Earlier, like China or Russia, or communist countries, they never part of some international institution. I can tell you, like WTO earlier, of course, now WTO earlier, IMF, IBRD, earlier GATT. These countries used to call that as bourgeoisie organizations, bourgeoisie, they never part of that. But today I can tell you, friends, why materialism I am talking about is that China struggled almost 15 years to become party, then earlier GATT and present WTO. In 2001, China joined WTO, but never, IMF, IBRD, they refused. Why they did it? Because they want to, develop. Why, now in the globalized world, one-to-one agreements, you have a bilateral agreements. By the time China joined in WTO, it has 6,000 bilateral agreement alone with the United States. China realized that it is impossible to do trade with all the countries, So that's why I remind, please remember that when you are parting to treaty, when you are consenting to treaty, when you are accepting treaty, friends, you are losing sovereignty. You are compromising your sovereignty. That ultimately you have to keep that in mind. I means countries. If China is becoming a party, or India is becoming a party to X treaty, means whatever that treaty says, we have to follow. Are you not compromised? We have compromised, but we want to be the part of the global society. Why? Because of global benefits. There are issues like MFN, national treatment, all those. So that's why, seeing in the broader context, now countries they are not care about small things. Okay, they want. Now China has to develop. Chinese, development is important. China people have to have everything, part of the global. That context, I said, all isms are going away. Again, materialism, definitely it is going to help the countries. And I am underlying the word. You want to gain something, you have to lose something. You don't expect in international law, but ultimately what you have to see that how your country can get maximum out of that treaty. So that is the ultimate object of any state. Okay, I'll try my best to get maximum out of that particular treaty, whether it's a WTO or any treaty. So that whether it's going to rulers all, I don't think rulers or kings or individual is immaterial in international law. So it is the states which ultimately benefit or not benefit or destruction, all those going to happen in the context of states, not as an individual, not as a ruler.
Last question, sir. Abhilash Srivastava. Sir, can Indian Parliament withdraw its commitment of conducting plebiscite in Jammu and Kashmir from United Nations?
Of course, that is the international issue that is happening. We can do as a sovereign country, but what percent of the territory which is occupied, all those issues you have to see. But ultimately, because it is a sovereign state, and particularly if you look at recent developments, Article 370, 35A, all those things, I don't see any problem, provided that we have to look at what is the extent of international law is involved. So that is, I don't know about that part, but as a a country, if they think that it is not going to help the country, but we have to see the repercussions. I don't know about without knowing the background, but generally, if country thinks that it's not going to help or detrimental, sovereign countries can take decision. Okay, like China refused to like what you asked, South China judgment. What international community is doing? We are urging, we are asking, we are requesting, but kuch nahi ho raha hai. That is what. So we can do that.
Okay, sir. Thank you so much, sir, for patiently answering all the questions, even though the time has exceeded. Now I request the head department of law and coordinator of the workshop, Professor Vinod Kumar Garu, to propose vote of thanks.
Thank you very much, Irfan. for conducting of this session successfully. Irfan and other team, Srinivas and other team, for successfully we are conducted today's inaugural session and also one lecture, excellent lecture by Professor Balakista Reddy garu. He is a registrar Usman University. Is best. He is one of the best teacher according to me because of excellent presentation. You have enjoyed a lot of informative session is here. I also learned something more than the about the international law. But whatever it may be, the international law depends upon only domestic law is more powerful than the international law. The state is more powerful when concerned with international issues. So this is one of the very important area you have touched, sir. And also you have given addressed all the questions which are required, which are posed by the all the participants. So thank you so much for giving your valuable speech and time and talent. Thank you so much, sir.